And we are live once again in Studio Thomas. And now we're going to talk about one of our favorite subjects. We need Paul over here, right? Paul in the orchestra, right? David Letterman show? Yeah. Supplemental jurisdiction. All right. Now, there's lots and lots of handouts here. Hopefully you've been doing them. There's practice essays and all of that. Just to start off with a reminder that SJ is like an ice cream cone. All right, here's the court. Here's the original jurisdiction. Original jurisdiction could be diversity, federal question. It could be a statutory interpleader, it could be copyright or patent, whatever. The magical words you need to see in the statute is that it's a basis for original jurisdiction in district courts in the United States. Right? If and only if you have OJ, then you can also have sprinkles. And the sprinkles are the supplemental jurisdiction under 1367. And the basic gist here is you can't have supplemental jurisdiction unless you have original jurisdiction. Now, under 1367, we have 1367A, B, C, and D. Now, a class and in the handouts, I refer to these as being granted, taken away, punt it, and save it. But if I give you an essay on this, please don't use those words. All right. Well, no, because those are mnemonics to you, like the ones on the website, right? Like, you know, for Conley used to be KISS, keep it simple, Sammy, and now it's, you know, show me the money, right? You know, these are learning devices for you. But in the essay, you know, keep it straight. You know, keep it serious. All right. So 1367A is the grant of supplemental jurisdiction. For there to be a grant of SJ, two things have to be shown, right? First, there's got to be OJ. There's got to be original jurisdiction. So show me that there's original jurisdiction. Okay. You may have to look at one or more of the original jurisdiction bases, right? Is there diversity? Is there a federal question? So on and so forth. All right. And here I'll refer you back to the study materials from the fall. I gave a very lengthy review in the fall on subject matter jurisdiction. You can go back and look at that. Time is not going to permit us to completely go over diversity jurisdiction, the federal question, and Motley, and Grable, and Holmes, and all that good stuff, you know, and so on and so forth. But under 1367A, first thing that needs to be shown is that there is original jurisdiction. If there's original jurisdiction, then we ask whether a common nucleus of operative fact. Now that comes from the Gibbs case, right? The statute itself talks about the same constitutional case, but Gibbs itself tells us the same constitutional case. That means there's a common nucleus of the operative fact. In other words, the relevant fact that's determinative toward the causative action in both the original claim and any supplemental claim. And then this is another example of, is this thing like another, right? What's the overlap in evidence, right? Overlap in time, all of that. Now, it may be that the scope of CNOF may be broader than the transactional test under Rule 13, okay? However, it is still somewhat akin to that test. It's the same kind of analytic tools and methods you bring to bear for TRO, you ought to bring to bear for CNOF, right? So 1367A, OJ, analyze whether there's OJ. If there's OJ, common nucleus, got to compare the claims, right? Now, if both of those hoops are satisfied, then you can go on to the next step, which is 1367B, which divests the grant of jurisdiction. All right? Now, 1367B has a couple steps as well. All right. The first one is, what's the basis for original jurisdiction? You have to ask, what was the basis for original jurisdiction? It may be that there's multiple bases for original jurisdiction. Maybe original jurisdiction was justifiable under both diversity and federal question. But what if the only basis for original jurisdiction is diversity? If that's the case, you have to continue. And you move on to the next step. Ask whether or not supplemental jurisdiction would be inconsistent with 1332. And if so, you continue. And the final step, you got to look at the laundry lists. All right? LLS, laundry lists. All right? There's 3 laundry lists in 1367B. All right? One of them, a claim by a person proposed to be joined as a plaintiff under Rule 19. Second one, a claim by someone seeking to intervene as a plaintiff under Rule 24. And third, a claim by a plaintiff against someone joined under Rule 14, 19, 20, and 24. Thank you. All right. What's common between all 3 of those scenarios? They're claims by plaintiffs. All right? They're claims by plaintiffs. Well, that should give you a clue. If the supplemental claim is won by a defendant, then 1367B is not going to divest, right? So those laundry lists are only going to kick in if and only if the claim is one brought by an actual original plaintiff. All right? Some of it falls into the actual P category. All right? Now, something else this tells you is you have to do a little bit of Joinder analysis, right? You have to figure out who the claim is being brought by and what the Joinder scenario is. Is this a claim that falls under, for example, this is a claim by a plaintiff, and is it against someone joined under Rule 20, right? Or against someone joined under Rule 14. So, for example, and here, what you can do, what you ought to do, is go through again the problem set, right? The problem set that I gave you has a lot of scenarios regarding supplemental jurisdiction, right? So, for example, let's see, P versus D for $100,000 for a car accident. D seeks third-party claim against third-party defendant for $100,000, and now the plaintiff asserts claim against the third-party defendant, 3-car wreck, right? Seeking $10,000. All right? Let's assume the parties are all diverse. All right? Parties are all diverse. State A, State B, and State C. Is there original jurisdiction over this claim?
Yes.
Absolutely. What about this claim? Absolutely. Original jurisdiction over this claim?
No.
No. All right. Same constitutional case, common nucleus. I said 3-car wreck, yeah? All right. So then under 1367A, we have OJ, and we have the same constitutional case, so there's supplemental under A, there's the grant. What about under B? What's the sole basis for original jurisdiction here? Diversity. Would it be consistent with diversity to allow P to sue D for $10,000?
No.
It wouldn't be. So now we have to ask, does this claim fall into a laundry list? First of all, is this a claim by a plaintiff?
Yes.
All right. Well, how would you characterize this? What kind of defendant is this? Third party joined under Rule 14. All right. This is a claim by a plaintiff against somebody joined under Rule 14. Is that one of the laundry lists?
Yes.
Yeah. So this is gone, right? Yeah, hasta la vista. And suppose it ran the other way, right? Same result. Because, and the analysis is the same up to the last step, right? OJ, OJ, no OJ, common nucleus, grant under 1367A. Is this a claim by a plaintiff? No. It's not a claim by a plaintiff against anybody. It's a claim by a third-party defendant against the plaintiff. This is okay. Now, if you look at Brittany's evil fact pattern that she gave you, something like this. after this person sued that person, this person asserted a compulsory counterclaim under Rule 13A for, I don't know how much it was, let's say $25,000. All right? What about this? Is this okay under 1367B? I don't know. There's arguments either way. This is very similar to Brittany's hypothetical, all right? And what I want you to do is think about this one. On the one hand, this is a claim by a plaintiff against somebody joined under Rule 14 and would be barred. On the other hand, this is a claim, right, and a compulsory counterclaim. What should we call P now regarding this compulsory counterclaim? A plaintiff? Or should we treat this person as a defendant on a counterclaim? I'm not going to tell you what the answer is, because you know what? There is no answer. What does the good lawyer do?
Argue.
Makes the arguments, right? And that's what Britt was getting at with her evil, wonderful, fantastic paper. I was snickering to myself when I read it. I said, wow, they're going to love this one. And we were thinking like, yelp. Yes?
Doesn't 13A1B answer that? On the compulsory one, it says, does not require adding another party over whom the court cannot acquire jurisdiction.
This person is already in the suit.
Yeah, but the claim.
We're not adding another party. This person's already in the suit, and they were properly added.
So you need personal jurisdiction?
This is not adding another party. This person's already there. I take it afterwards. We'll discuss that. All right. Now, don't forget that there's more supplemental jurisdiction than just 1367 A and B. 1367C kicks in if A is satisfied, there's the grant, and B does not divest. All right? If you have the grant and you don't have divesting, well, the court under 1367C can still exercise its discretion to decline supplemental jurisdiction. There's a number of factors in there for you to look at. Look at them. Under D, if the court dismisses, then D contains a savings clause that delays the expiration of a statute of limitations, all right, for 30 days. So the key question there is going to be, was the claim timely filed in the first place? If it was, then the party gets 30 additional days to refile in state court. Alrighty. All right, I think that's it on supplemental jurisdiction. I'm going to pause the tape and we'll move on to the next subject. Oh, I will note one thing, actually quite important. Don't forget about removal. Supplemental jurisdiction can be important in removal scenarios as well, right? So if I give you a fact pattern where a case is filed in state court, and that's removed to federal court, and then you have to analyze subject matter jurisdiction, consider all the stuff that you'll have to analyze. You'll have to analyze what? Was removal proper, right? Is there original jurisdiction? Is there supplemental jurisdiction? Just keep that in mind. All right, I'm going to pause.